Thank you, Mr. Chairman. Just following on from the issue that Simon Bridges raised then, I agree with Mr. Bridges in respect of this issue. Now, and indeed, I wonder whether the preliminary provision, paragraph A, which presently says the purpose of this Act is to promote access to justice by establishing a system that provides legal services to people of insufficient means, I would suggest that it might better read provides appropriate legal services to people of insufficient means, because I do agree with Simon Bridges that we do need to take care that we don't cross a line so that we're actually funding through legal aid for people of low income things that they actually wouldn't fund for themselves were they high income. It's one of the tensions that you have in legal aid, because if you make legal aid available at low or no cost, and in respect of a low-income person who has no realistic prospect of paying back what is in theory meant to be a loan, it effectively is a grant to them forever, and there is little financial incentive on them to appropriately modify or control their own expenditure on legal fees, because in the end they don't pay the bill. And I think that there are a couple of areas that are yet to be properly controlled through the legal aid system. I'd like to hear from the Minister's view as to how it is that this purpose, in tow with the relevant parts of the other bill, achieves proper control of criminal appeals and multi-party drug trials. Because in respect of, I'll deal with it, the first one. In respect of criminal appeals, there used to be a system run in New Zealand where criminal appeals, particularly to the Court of Appeal, were controlled by the judges themselves. And there was a Privy Council decision that said that was inappropriate, that the judge ought not to be the gatekeeper as well as being the judge in the substantive merits of the appeal, or on the substantive merits of the appeal. And I can understand why the Privy Council found that, and I think that was probably a wise decision. But in the process, the only stop on, or the only effective stop on everyone who wanted to exercise a right of appeal in a criminal matter being paid for by the state was thrown out, and we haven't had a replacement gatekeeper. Now, I absolutely believe that we should be enabling people to have fair access to legal representation in respect of their first appearance, but I'm not convinced that everyone who wants to appeal, if they can do so more frequently as a legally aided appellant in a criminal appeal, I'm not convinced that everyone should be funded by the state, effectively at the cost of other taxpayers. So there needs to be some mechanism in the system to stop what is effectively a proliferation of criminal appeals that wouldn't happen if these people were pecunious, i.e. had the money and were paying themselves, because they would be more likely not to pursue an unmeritorious appeal. Now, that's one issue. So I think we should have the word appropriate in there, because this is money that is short of, and I'm not sure that this bill quite gets that yet. The second point is in respect of multi-party, multi-defendant trials. Multi-defendant trials can arise where you've got complex drug crimes. You have a number of defendants, and often their interests are just about identical. But you can bet that if they're on legal aid, they'll all have a separate lawyer. Whereas if they weren't on legal aid and they were paying their own defence, they seem to remarkably be able to agree that they should cooperate and share the expense of a lawyer. And instead of having 5 lawyers all being paid, we actually, by the state, they somehow managed to cooperate and agree between them that it would be much more sensible that they only have one. Now, that aspect of criminal legal aid over expenditure needs to be controlled as well, because not only does it cause a waste of cost to the state in respect to the legal aid costs, it actually elongates the trial. You have 5 people jumping up just cross-examine the same witness, all showing how good they are at their jobs, and it elongates the period of time for the trial, so that the trials run a lot longer. They're a lot more complex for the judge to manage. Takes a lot more time when it comes to the prosecution, takes a lot more time when it comes to the police and the other witnesses that have to appear, and the whole thing becomes more complex and more expensive. Now, the quality of justice cannot be divorced from its accessibility, but that doesn't just run for the accused or the defendant. It actually also runs for the overall cost of the process as to whether governments can afford to run decent judicial systems, and actually we see this even more so in respect of civil proceedings. And in respect of civil proceedings, Minister, I would suggest that it's important that the attorney who has conduct of civil proceedings rules exerts controls, because actually in a constitutional sense they are the attorney's rules.